Hi, my name is Glenn Smith, and we're here to do a New Jersey legal update. I'm joined by my colleague, Meredith Berger. I'll do brief introductions a little bit later on. This is 3 presentations for the New Jersey State Golf Association 2021 Virtual Golf Summit. So just by way of introduction, I'll go forward to who's going to be doing the speaking. I'm a partner at Seyfarth Shaw. I focus on labor and employment matters. And Meredith, why don't you introduce yourself too?
Sure. I'm an associate at Seyfarth. I work with Glenn on a lot of different employment counseling issues. I also do my fair share of employment litigation, but I'm excited to be here today to talk to you all about these issues in New Jersey.
And as you folks know, I have a fairly significant practice within the golf industry as well. We've specialized in doing a lot of different presentations and meetings and counselings with multiple golf clients and for multiple golf associations. So without further ado, I'll let Meredith take us through the agenda for today.
Sure. As Glenn mentioned, this is going to be a 3-part update. We will be doing part 1 in this first session, and we'll be going through some highlights of New Jersey labor and employment law general updates. In part 2 of our series, we'll be doing a COVID-specific focus on that update, and then our third in the series will be surrounding New Jersey independent contractor updates. So without further ado, to get into the substance here, I'm going to first focus on the New Jersey law called New Jersey CREAMA, which legalized marijuana and has significant implications for employers. The law is extremely long. It's made up of several bills, and so we try to distill the main points for you here today. The first point being that employers can still prohibit marijuana impairment in the workplace. You do not have to allow employees to come to work high, and this is true also for guests and other visitors that may be on your property as well. You can certainly prohibit the use of marijuana at your property. However, please keep in mind that employees who use medical marijuana do have to be accommodated in their use of that. So while they do not have to be allowed to come to work under the influence of medical marijuana, but you do have to engage in the interactive process to accommodate employees who use it. Another aspect of this law is drug testing limitations. This can get very complicated. So if you do drug test, just be sure that you're not taking adverse action solely because of the use of marijuana or a positive test result for marijuana metabolites, and keep in mind that there are, for drug testing that arises as a result of reasonable suspicion, if you suspect that someone is high in the workplace, there is a higher standard under this law. So not only do you have to have some subjective view of the person that makes you think they're high, but there are also objective elements as well. The law, we can go to the next slide, Glenn. The law's effective date is yet unclear, so nothing to worry about just yet, but keep an eye on our alerts, on our updates that Seyfarth puts out, because we will be providing additional updates on this as the law goes into effect. We're waiting for some rules to be issued in order for that to happen. And an important point here is that there's no expressed private right of action for employees, so they can't bring a lawsuit. But there are certain penalties that can be levied against employers. For pre-employment inquiries into criminal history surrounding marijuana or hashish charges, related charges or arrests, just know that you cannot inquire or base an employment decision on a prior arrest, charge, or conviction of any of these offenses, and that includes the sale of marijuana. So there is quite a broad, the law legalizes in quite broad terms. It's not just the use, but it's also the sale or possession. So it's as if those offenses were never crimes. And so when you do a criminal background check, just be sure that you're either not screening for these type of offenses or you're taking them off the report so that there's no appearance that you use this offense in order to make the employment decision. Again, for this law, there's also no private right of action, but an employee can bring a charge, and it comes with some hefty penalties, especially if there's more than one violation, which could be the case if your reports consistently show marijuana-related offenses.
Meredith, I could just add sort of one big takeaway here is when we take a look at this new law, it doesn't change the way you can run your club in the sense that you don't have to allow marijuana to be used on property, as Meredith was saying. And certainly that's something that we recommend for everybody and frankly for every employer. But the other piece of it is that when you're doing your hiring and when you're considering all these different things that we've always looked at, whether it's background checks or whatever that you're doing, there's some real need to be cautious about what's going on, and also to be very cautious about what employees are doing in their off-duty time and how that's going to impact. So it's going to be a totally different world once this thing gets, once it becomes active.
And just to jump into some quick overview of New Jersey sick leave laws, you all are probably aware that for the past 3 years or so, New Jersey earned sick leave has been in effect, and that provides 40 hours or 5 days of paid sick leave. But in addition to that, there's also paid family leave, which in New Jersey is called family leave insurance law. That was just increased to 12 weeks last July, and it additionally allows 8 weeks of intermittent leave. So if you have employees who are going out on maternity leave, taking leave to care for a family member or to bond with a child, this is something that you should be aware of that they're entitled to. I would note that New Jersey Family Leave Insurance is not itself a leave entitlement. It is merely pay that the employee can take. However, you should be careful if you're denying the leave under any circumstances, really, that when an employee requests to take it. Family Leave Act leave, the New Jersey FLA, is the state analog to the FMLA. It also provides 8 weeks to care for either a new child in bonding leave or to care for a family with a serious health condition. It's designed to be taken in conjunction with the FLI so that the employee can receive pay when they're out on leave. However, note that Family Leave Act does not cover an employee's own serious health condition. For that, the employee would turn to FMLA and then could also get temporary disability benefits, which is a partial wage replacement for any sort of temporary disability. In addition to this, don't forget we have workers' compensation and unemployment that employees can also take advantage of.
When it comes to these leave items, I would just say you should probably do what I always do, which is I usually go to Meredith and because she knows it so much better than I do. But I think this also has a big overlay with some of the other topics we're going to be talking about, including caddies. If the caddies were employees, these are all the different things. If they're going to be treated like employees, these are all the different things to which they would become entitled as well, as opposed to if they're contractors who are given services to the golfers.
Yeah, in terms of just sort of looking at it from a 50-state perspective, New Jersey is one of the most liberal states in the country, and especially with regard to leave entitlements. Their laws, not only do they provide a lot of leave for employees, but they're also written in a very employee-friendly way. So it's not as sort of common sense as one would think. And also, when you Google things and you look up things on the New Jersey Department of Labor website, I find that they're outdated. So you can't necessarily rely on just sort of quick looking it up. You really do need to speak to someone who has expertise in this area. And this is actually something that the New Jersey Department of Labor put out that is updated, and it is a COVID-19 scenarios worksheet that lets you know what benefits are available for different scenarios. So in terms of COVID, we had FFCRA, which is no longer mandatory, but we also have New Jersey state-specific, as I went through the overview. So this is a good source to just keep an eye out on and look at, and you can even use this as a starting point to see if, this is the employee really does get some kind of leave, like if the employee is getting the vaccine and doesn't feel well, you want to just do a quick check to see if there's anything that the employee would be entitled to. We can go to the next slide. And this is just the rest of the worksheet. But as I said, it's a pretty neat guide that you can use as a starting point.
Yeah, and the leave laws are incredibly complex. It's a patchwork across the whole country, like Meredith said, and New Jersey being probably one of the most difficult states to sort of figure it out. And in fact, they're coming out with more and different leave scenarios each and every day. I mean, right now we're tracking a new bill that talks about a COVID vaccine leave. I don't know if that was on that prior slide, but there's going to be certainly some time given off for people with pay to go get COVID vaccines. And we'll deal a little bit more on the COVID stuff in our second presentation. In terms of something else that's unique in a sense and also very stringently enforced in New Jersey, it happens to be wage payment. I mean, generally speaking, employers are required to, of course, pay the minimum wage, which is going to be increasing up to about $15 within a very short period of time over the next 2 years additional. However, market demand, as you folks know, is very difficult right now as well. So in many instances, we're seeing, and in cases of restaurants trying to hire employees, and in terms of every small business who's looking for employees, that the starting rates are going considerably up. But obviously, you have to pay the minimum wage. One other thing that all employers must do is that you must accurately track all time worked, and that includes time that people are on the property having to suffer what they call, the state uses that word suffer, waiting time. Also, you have to maintain pay records in your location of work for all hours that are worked. And, New Jersey, like most states, I mean, obviously requires a tracking of this. New Jersey's more aggressive on the enforcement side. What they've now come to allow is liquidated damages of 200%. So, for instance, if an employee is owed $1,000 in back wages because we haven't accurately kept track of either their hourly pay or their overtime pay, the reality is they would be entitled to $1,000 plus an additional 200% of that, an additional $2,000. So the employee would get $3,000 plus any fees and costs associated with trying to collect that money. And that goes for when an employee files a lawsuit against you for unpaid wages. So this is a real incentive to the wage and hour class action attorneys out there who are looking to bring these types of claims. There is a limited defense that's available to employers, and it really requires catching the violation within a very short period of time and essentially turning yourself in. The other thing that applies is that the statute of limitations for wage payment issues goes back 6 years. So if you've been underpaying somebody overtime or wages over a period of time, they can look back for 6 years. It'll end up being tripled in totality, plus the cost of the defense, cost of the attorney's fees for prosecuting the case you could be on the hook for. So that's a very difficult statute for us to abide by. But there's even more, and the more is that it's now accompanied by fines and potential criminal imprisonment. We haven't really seen the state imprisoning people, as far as we know, for this. But the reality is that New Jersey's wage theft statutes now contain a criminal element to them that allow imprisonment for the decision makers. This is pretty unique amongst states. There are a couple of others who do it. We like to say that whenever California gets started on it, then we're going to sort of migrate into a situation where New Jersey or New York is looking into it, and the more progressive the states are, this is what they're doing. Also, the one thing to keep in mind that each violation that you are held responsible for, it's based on a week. So if you do have multiple weeks of a violation for any employee, that becomes multiple subsequent violations that takes you up the chain with regard to where you would fall on these penalties that are applicable here. Meredith, I don't know if you had any comments you wanted to make about the wage stuff?
No, I think you covered the,
Perfect.
Yeah.
So these we can kind of sort of bat them back and forth, but Meredith, you want to talk about the New Jersey law against discrimination just for a second? And I think there's some amendments coming up on that we're hearing about.
Yeah, there is a bill that we have been tracking. It's currently still sitting in committee. It hasn't gone anywhere yet, but the law is revived from pre-COVID era, and the New Jersey law against discrimination is already one of the most liberal anti-discrimination laws in the country, up there again with New York and California. And courts also interpret it very liberally. So it is already increasingly difficult to get what we say summary judgment on the motion, meaning to dispose of the motion on a legal theory rather than have a trial and have to have it be heard before a jury. So this new law would do a lot more to, cut the sort of knees off employers here in mounting any sort of defense, including taking away a lot of defenses to harassment, where, if the employee didn't report it, there is usually a defense that the employer can assert, and it would take that away, among other things, just creating a very, very liberal statute out of what's already pretty liberal.
Yeah, and I think it includes a lot of home worker sections too. So like people working, domestic workers in the home, and giving them certain rights as well, which would really be an interesting wrinkle on it as well. So we'll keep following that and see where that ends up. One of the ones where we have seen significant action in 2020, and a little bit of it got blurred by COVID-19, is New Jersey put out, after gathering a bunch of data in 2019 under its independent contractor task force, they put out 6 new laws in 2020, all of which were really designed to hone in on contractor compliance, and all of which are honing in on whether the persons who are classified as contractors really should be classified as employees. And you'll see we put links in here too, so when you go through the presentation, hopefully you'll be able to click on those links and be able to get to the information. But included in the contractor compliance legislation that came out in 2020 is a required poster that all employers are supposed to maintain throughout their establishments. And that poster makes it perfectly clear what the test is for independent contractor law. It also makes clear what the penalties are in terms of back wages that could potentially be due. And it also makes clear that that any contractor who makes an allegation that he or she should have been an employee is covered by its own sort of whistleblower protection. So it's another one where we could say a patchwork of new legislation to cover a topic, and it really indicates that New Jersey is bound and determined to enforce the ABC rules, and we'll get to those more in the third part of this presentation, that apply to analyzing whether somebody is a contractor or not. The mandatory arbitration is actually a little bit of a glimmer of good news for employers. A couple of years ago, New Jersey adopted some pretty strict legislation that was geared toward eliminating arbitration or mandatory arbitration for employees. The decisions that have come out from the courts have found that that legislation is unenforceable. And so the fact remains, on a very simple and basic level, that employee mandatory arbitration remains something that you can do. New Jersey WARN is one that we've written on quite a bit. New Jersey WARN has been amended. It was amended twice during 2020. And in terms of what's new about it, there are some very strict requirements that will be in place once we get 90 days after the state of emergency for the pandemic ends. So that's something that you should really be cognizant of if you're going to have a large layoff. Meredith Crown Act, do you want to cover that at all, or the Hairstyle Act, or go ahead if you would.
Sure. Well, this law is one that we're seeing in other states as well. Connecticut, New York just passed them, in addition to New Jersey. And this is a law that bans hairstyle discrimination and is specifically tied to race. So you just want to make sure to update your anti-harassment policies to make sure that, you're covering this aspect of it, update your harassment training, and if you do offer it, and then make sure that employees are able to wear their hair in a natural way if that's what they so choose to do. Do you want to jump back into SEPA?
Sure. Just a couple of notices that are required annually. We always remind folks when we get to them that you're supposed to put out your Conscientious Employee Protection Act notice. That's basically the New Jersey whistleblower statute. There's an annual notice that has to go out to all employees. There's also an equal pay statute notice that has to go out and be posted each and every day. What other things are on the horizon? I mentioned before vaccination paid leave. It looks like that bill is making its way through, and I think that'll probably become law. And then we've also heard and seen some additional details about a potential for Fair Work Week laws becoming more prevalent across the country and including in New Jersey. And those Fair Work Week laws, there's one that exists in New York now with regard to fast food establishments especially, and it has to deal with making sure that the schedule that people are provided in advance of performing work is adhered to. So it provides for penalties in the event there are late scheduling changes, and it also provides for exclusions from adding somebody to the schedule too late. For instance, if it wasn't on their schedule and you want to bring them in, there are all sorts of different requirements that exist with regard to whether or not you can actually change the person's schedule. It's not in effect in New Jersey, but I know that's something that they're talking about. So just to sort of wrap up this presentation, the first of our three, we wanted to remind you all that we have a whole host of relevant subscriptions that you can sign up for that are free. Again, this isn't meant to be attorney advertising here. This is meant to be a service to you all. But we have COVID-19 updates. We have subscriptions for any different number of areas of law, including a number within labor and employment. Our firm's a general practice firm, but we have an enormous labor and employment group of about 450 people. And finally, we also have a golf and private club industry mailing list as well. So those are all things that you can sign up for. Obviously, it wouldn't be a legal presentation without some sort of legal disclaimer. And this is just to let you know that nothing in this presentation is intended to constitute legal advice. We're trying to give you information about things that you should be focused on. We encourage you to seek with your professional counsel. Obviously, if you need counsel, we're here to help too, and you can email Meredith or I anytime, and we'd be happy to talk to us. Just because you send us information doesn't mean we've been engaged. We always have to go through a thoughtful engagement process and make sure that we cover all conflicts as well. So with that, I don't think we have anything further on this topic, and we'll move to the second one. So thank you very much. There's Meredith's information and mine as well. Much appreciated.
Thank you.